Finally, we win a big one at the Supreme Court, a case with far-reaching implications and on a critical issue, namely voter integrity laws. The Supreme Court appears to be saying in this decision that it doesn't want to look at the 2020 election. It doesn't want to, you may say, investigate whether the horse was stolen. But it is going to let states lock the barn door, which is to say to take practical measures to ensure against the possibility of voter fraud in the future. And the left, of course, is screaming because they hate these voter integrity laws. And their main argument has been that these laws are discriminatory. They make it harder to vote, in Biden's phrase. And the good thing about a Supreme Court decision is that these arguments engage each other. We find in the legal reasoning of the decision, and I have the decision right in front of me. It's 80 or so pages. It's about 40 pages, single-spaced. But it is a very illuminating clash between Alito, who writes the decision for the majority. By the way, it's a 6-3 majority. All the conservatives are the 6, and the 3 progressives, Kagan, Sotomayor, and Breyer, are on the other side. And so we get a kind of a Kagan writing the dissent. We get kind of a sharp contrast of views and a contrast of legal reasoning. Now, we're talking really about 2 things in an Arizona law. Arizona's voter integrity law requires 2 things, and Alito sums them up, so I'm going to read. Voters who choose to cast a ballot in person or on election day must vote in their own precincts, or else their ballots will not be counted. That's provision number 1. Number 2, mail-in ballots cannot be collected by anyone other than an election official, a mail carrier, or a voter's family member, household member, or caregiver. In other words, this whole idea of a guy showing up with a suitcase of votes. Oh yeah, I got these from a bunch of guys in my neighborhood. That is not going to fly. So now, here's the question. The question before the court arose out of a provision in the Voting Rights Act. The Voting Rights Act was initially passed in 1965, I believe, but it's been amended subsequently. And basically, the Voting Rights Act simply says that you can't have a voting law that, quote, denies or abridges the right of any citizen of the United States to vote on account of race or color. Now, that is broad enough, but what does it actually mean? Now, in 1980, the Supreme Court said that what it means is that the law in question, the law that falls afoul of the Voting Rights Act, must be discriminatory in intent. So not merely in effect, it must be discriminatory, it must have a discriminatory motive. But that, of course, is hard to prove. So Congress sort of amended the Voting Rights Act basically to say that no voting law can be passed that, quote, results in the denial or abridgment of the right to vote based on color. Now, here's the question. Do these Arizona provisions, which are on the face of them neutral, because after all, they don't single out blacks, they don't say things like, well, blacks can't do this, but everybody else can. They're facially neutral. They apply to the whole voting community. And the question is, do these constitute a violation of the Voting Rights Act? Now, the Circuit Court of Appeals, which took the decision sort of one rung down, said yes. They said, quote, Arizona's policy of discarding out-of-precinct ballots have a discriminatory impact on American Indian, Hispanic, and African American voters in Arizona. Now, how is this even possible? How do they have a discriminatory impact? Well, it turns out that the appellate court said that American Indian voters, minorities, quote, renters, and poor people don't really have the habit of using the mail. Quote, minority voters rely on third-party ballot collection for many reasons. So the idea here is that here are these American Indians, and they don't like to use the mail. They don't like to also show up in person. They just like to sort of, hey, Chief, Running Bear, come over here. Here's 800 ballots. Why don't you take them in for all of us? So this kind of stuff, apparently, it was the basis of the appellate courts saying that the Arizona law was invalid. And of course, this is now picked up by Elena Kagan, who basically says, oh yes, we're not supposed to just look at the intent of the law, but we have to look at the discriminatory impact of the law. So the idea here is that if you have a law, even if it's facially neutral, but it has a disproportionate impact on different racial groups, that by itself creates a presumption that the law is invalid. Now, this is exactly the issue that Justice Alito takes head on. And Justice Alito starts off by saying, wait a minute. He goes, first of all, he says, voting does impose burdens on everybody. After all, it takes effort to vote. Your vote doesn't magically transfer from your mind into the machine. You have to show up to vote. You've got to take the trouble to request ballots. You've got to send in your ballots. So voting imposes burdens on everybody. The question at hand is, does this type of voting law rule impose an unfair burden on certain minority groups? And Alito says no. He says, first of all, every state has a, quote, strong and legitimate interest in preventing fraud. This is a key point. He says, quote, fraud can undermine public confidence. He says there's another important consideration here, and that is voters should be able to vote without intimidation or undue influence. And this is why, for centuries, countries have used, quote, the private voting booth. So people can't strong-arm you into voting a certain way, or you can't go to a nursing home and sort of pressure people to all vote for your candidate. And then you bring the ballots in. So Alito is saying, no, states have a right to protect the integrity of their votes. Second, he says, this is a key point, that a quote, a law is not discriminatory even if its impact falls unevenly on different groups. So the general idea here is that, I'm quoting him now, the mere fact that there is some disparity in impact does not necessarily mean that a system is not equally open or that it does not give everyone an equal opportunity to vote. So let's just say, for example, that American Indians have a cultural practice of not using the mail. Well, okay, then you can show up in person and vote. So you have options. You're allowed to vote. They've actually, Arizona, the court agrees, has made it easy to vote. But the simple fact that your group doesn't feel like using the mail because, we're just not into the mail, doesn't mean that allowing mail-in ballots and establishing some ways in which those can be sent in is, quote, discriminatory against Indians. So this is the kind of illogic that the left has been using very effectively in other cases, but here the court clamps down and goes, no, that's not the way to go. The court looks at, quote, the totality of circumstances in which Arizona passed these rules. And finally, Alito makes an absolutely critical point. He goes, the left is constantly saying, well, you haven't actually proven that there was discrimination. You haven't proven the need for this voter integrity law. And Alito basically goes, so? He goes, you don't need your house to be robbed before you establish an alarm system. You don't need to have proven that there was, in fact, fraud and there was, quote, a need for a ballot integrity measure. States are perfectly free to say, listen, whether or not there was fraud the last time around, we just don't want to have fraud in the future. And therefore, we're going to do A, B, and C to ensure against that. One more quote from the opinion. Having to identify one's own polling place and then travel there does not exceed the, quote, usual burdens of voting. It's kind of hard to believe you have to have the Supreme Court actually saying such obvious statements that when they give you, it's kind of like saying, you have a local public school to go to. You want to go to another public school, but this is the school in your district. This is the designated place for you to go. It's not exactly discriminatory or doesn't impose undue hardship to ask you to go there. Now, of course, all of this has, as I say, wide-ranging impact because the Biden administration, really right before this decision, filed a lawsuit against the Georgia integrity law. And that, if you read it now, you have to sort of keep laughing about it because all the arguments rejected by the Supreme Court are coughed up in that lawsuit. So you can safely assume that lawsuit is pretty much of a dead letter at this point. And this is also a green light to other states to pass voter integrity laws, because the standards of having those laws are clearly set forth here. There's nothing wrong in protecting voter integrity. You don't have to prove that there was some pre-existing fraud. It doesn't matter if there's some disparate impact, as long as you're allowing everyone to get out there and vote some way or the other. You're not singling out a particular group. It's perfectly fine to go ahead. Of course, here's Biden in his usual kind of mumbling, bumbling mode. Today's decision by the Supreme Court undercuts voting rights in this country. And he basically says, this is why we got to pass the For the People Act, or the John Lewis Voting Rights Advancement Act. Quote, our democracy depends on it. And the sheer idiocy of this, what, our democracy depends upon laws? You know, it's a mortal threat to democracy to tell people, listen, you got to vote at your own polling place. And you've got to show up in person, and it's got to be you. It can't be somebody else. And no one can show up with a Volkswagen full of ballots. All of this, according to Biden, is a grave danger to our democracy. So these people are beyond parity. And I think the Supreme Court is onto them. They recognize that this is basically you can almost call it the guys who are trying to make it easy to cheat. They deny that. They say, we're not doing that. We're just trying to make it easy to vote. But in making it easy to vote and removing authentication requirements, you are also making it easy to cheat. And it's hard to believe that the Democrats who are pushing for this don't know that. The Supreme Court, which has disappointed us in some recent decisions, has finally come through with a big one. And for that, we should be grateful.